Hello, everyone. How's it going? This is immigration attorney Moumita, and I am here to talk to you live about immigration and the questions that you may have on your mind. For those of you who do not know me, my name is Moumita Rahman. I am an immigration lawyer. I'm based in New York City, but I work with clients all over the US. So don't let geography be a barrier to you giving me a call if you are looking for assistance on your immigration case. And one of the things that we work a lot on is working on cases for persons who have started a marriage green card process or who are married to a US citizen and are looking for ways to be able to keep holding on to their green card status or to get their green card and work permit when they may have lost hope that the marriage is not going to work out, or they may even have an illegal entry and are under the or have been told that they have to leave the US in order to get a green card, or that they can never get a green card. And what I like to do is I like to look at as many cases as I can for as many options as possible to see what person's abilities are in order to legalize and get their status fixed. And today, my question that I'm going to talk about in particular is, if you're married to a US citizen and you already started your green card process, but you want to get a divorce, but you're too scared to get a divorce because you're afraid of what will happen to your case, what are your options and what can you do? It's a very important question because a lot of people may be stuck in a relationship where they marry somebody who turns out to be not who they thought, and life becomes miserable and life becomes a nightmare, and you may feel stuck and unable to leave because you are afraid of losing your chance to get a green card, you're afraid of getting deported, and you're afraid of the consequences of what will happen to you. So we're going to talk about that right now. But again, if you're joining me right now, make sure you write my phone number down. My phone number is 212-248-7907. And although I am based in New York, I work with clients all over the US. We have a highly efficient, capable team. We work with clients virtually, so you're not going to miss a thing. In fact, you're going to get even better service from us than you could probably get from the attorney in your town. And if you're in an area without good legal representation, without good choices for attorneys, definitely I want you to write my number down and see if you can give us a call. All right. And hello to Salman, Jean, D&D, love, hello. And go ahead and drop me your questions in the commentary box. I'll go ahead and answer as many immigration questions as I can in the time that I have tonight. And as I do every single night, I'm going to talk about this one particular topic. Hello, Tiffany. How are you? What are your options if you have already started your green card process with a US citizen spouse or a green card holding spouse, actually, and now you're just thinking that you can't put up with the behavior anymore and you need to get a divorce, but you're worried about getting a divorce? Do you have any options, or are you basically trapped until you're able to fix your status and then you're thinking about your exit plan? Well, the thing is, ladies and gentlemen, you don't always have to stay in that sort of a relationship. When you're not in a healthy marriage where your spouse is, just putting you down constantly holding the green card status over your head, or you also feel like your spouse keeps trying to sabotage your case by not giving you documents, by forgetting about deadlines, by refusing to show up to the interview, and you've been just living with this constant pressure, fear. Sometimes you may even have spouses that bring up your immigration status in a way that's almost like a threat, right? Like as though, like, if you don't listen to me or if you don't do X, Y, and Z, then who knows, maybe I'll cancel your case. That, my friends, is actually something that is called emotional manipulation. And these are signs of emotional abuse. Where there's one sign, there's almost always other things that are happening, as I have learned from my experience over the years. And I don't want you to be, feel that you are trapped in this relationship, because what you should know is that you may have the option to actually continue your case by yourself and file and ask for something called a VAWA self-petition. And a VAWA self-petition is a way for the spouse of a US citizen or of a green card holder to be able to seek a green card on their own without the help of their spouse, without the interference of their spouse, or without the intimidation of their spouse, where you are suffering extreme cruelty or physical battery. And extreme cruelty is basically, this is something that I want to explain for you. Extreme cruelty involves anytime your spouse keeps doing things to you that are hurting you emotionally, that are causing you psychological harm, that are basically causing you to be living underneath some sort of fear or control. And as an immigrant, when you are without papers, a lot of things can amount to this because of the fact that you are constantly having this fear of having your immigration status stopped and canceled and of getting deported. So unfortunately, there are a lot of people out there who can use this to their advantage, all right? So if you're living in the situation where you have started a case and you have been constantly thinking about divorce, but you are afraid of what's going to happen to your case, what's going to happen to your kids, what's going to happen to your status if you stop the process, and you've just been kind of putting up with things even though they're hurting you so much, just so that you can get your status fixed. Well, the good news is that you may not have to do that. I do want you to give me a call, 212-248-7907, so I can take a look at your case and let you know if you have a good option to continue by yourself, okay? Now, what happens though if you have already gotten divorced, right? You started your process, you either got denied or you got divorced, and now you're still in that same position where you have still gone through this sort of a relationship with your spouse. Well, it may still be an option for you, even if you separated, even if you divorced. However, your divorce cannot be more than 2 years ago. So still give me a call so we can review your case to see what your options are, okay? All right, so now I'm going to go ahead and turn over to my questions that I have. And thank you to everyone who's watching. Hello, Zoheb, my friend, how are you? Nice to see you. And someone's asking, will I answer the phone? No, actually, I don't answer the phones directly. I have a whole team who are basically answering the phones. So if you're gonna call, you're gonna be in touch with my assistant who will book you for an appointment. Okay. What does it mean after U.S. citizenship test that they say that they recommend you for approval from Kemi Baby? Kemi Baby, and thank you for this question. And anyone who has gone for their citizenship interview or are planning on going for their citizenship interview, here's the thing. After the end of every interview, you will always receive a paper that says whether you are recommended for approval or whether your case is still being held for review. When you receive this decision letter from, it's not a decision letter, it's more like an interview results notice. When you receive this interview results notice from your immigration officer that says that congrats, your case has been recommended for approval, basically means that you've been recommended for approval and there's nothing else between you and getting naturalized. And you simply have to wait for your oath ceremony notice, and then you'll become a citizen. And if you have had your citizenship interview and it says that your case is being held for review, that could be due to a variety of issues. For example, almost anyone with any sort of criminal history, any sort of criminal charges, even if it was 20 years ago, even if it was dismissed or sealed, anytime you have a criminal history, your case will almost always be held for review when you try to naturalize, because it usually requires further investigation, and it will also usually require the approval of a supervisor as well. But don't lose hope. Sometimes, I've had, I've had plenty of cases where clients have had criminal convictions and we have the case held for review, but we still get ultimately approved because I've already gone in prepared to argue that this criminal conviction does not matter or should not affect my client's case. And this brings me to it's a very good point. If you have any sort of criminal history and you're trying to go through immigration for anything, you need to disclose everything. I don't care how small it was. I don't care if it was 30 years ago, 40 years ago, if it was in a different country, or if, it got dismissed, sealed, expunged, you were pardoned by the governor. It does not matter. If you have ever had any sort of encounter with law enforcement, you must disclose it. And a common mistake that I see on people's cases is that they only reveal or they only write down things that happened in the past 5 years. No, my friends, immigration wants to know everything. And guess what? They are going to have access to all these records. If you've ever been fingerprinted anywhere or your name has been written down and it's in some sort of FBI log, it's going to show up in an immigration search. And, you may be disqualified from getting approved because if you're caught lying or misrepresenting the fact that you were previously arrested, then you may be deemed to have bad moral character, right? So definitely you want to disclose and you want to be able to explain. And another important thing when you have any sort of run-in with law enforcement is that you must be able to provide the records to show what happened in that case. What was the final ultimate disposition of that charge and that conviction? You need to have the copies ready, original certificates ready before you go to your interview. It's vitally important. And the other thing that I would say is that it is vitally important to have a immigration lawyer with experience represent you for these cases. And of course, every single criminal instance needs to be analyzed and documented and prepared for in advance, okay? So if you do need assistance with this, 212-248-7907. Also, because there are plenty of criminal convictions that may actually disqualify you from citizenship. William, walaikum assalam. How can a fiancé visa application happen? Please help, from Madame Shiadzonichi. So for a fiancé visa application, you need to file something called the I-129F, and you also need to be eligible for it, which means that you and your fiancé must have met at least once in the 2 years prior to making the application, and neither of you can be legally married to anybody else at that time. Is an immigration attorney the same as a removal defense attorney? From Best Friend Tyler. Best Friend Tyler, yes. An immigration attorney that does removal defense is simply an immigration lawyer that does court cases for removal defense, which is basically deportation cases. So somebody who does removal defense is basically someone who is trying to represent you in court and to keep you from getting deported, okay? And that is also something that I do. I do not take every single sort of case, but I do travel all over the country for these cases. Let's see. How long to get the interview after the I-130 is approved? I'm a citizen and my wife is in Pakistan, from Hashimi Assad. Hashimi and anyone else who is filing an I-130 for their relative overseas. I-130s these days are taking anywhere from 8 months to a little more than a year. So it's definitely, I would say, an average of a 1 year waiting period, if not more. Okay. Let me turn over to my YouTube family. Hello to everyone. Abati is asking, I would like to know if a VAWA-based green card can file after 3 years. If I stay 8 months out of the country, will it affect the ability to apply for citizenship after 3 years? So first of all, if you have been approved for VAWA, it means that you have gotten your green card on the basis of being in an emotionally or physically abusive relationship. If you get approved for VAWA, then you get the same benefit of being able to apply for your citizenship after 3 years of residency. However, as far as will your 8 months out of the country affect your case, it very well may, Abatia, because when anyone has been out of the country for more than 6 months, it creates a rebuttable presumption that you gave up your residency. And if when you have a green card and you want to become a citizen, you have to show that you have been inside the U.S. for, that the U.S. is your main residence. And anytime that you're outside the U.S. for more than 180 days can make an argument that you don't have that. I have the VAWA pending and I just received the prima facie. It's in more than 24 months. What should I do? So Jean Ziza, if you have applied for VAWA processing times right now are between 18 to 24 months. If it's been 24 months, I would say just have a little bit more patience. My spouse and I have both been interviewed and our case has been in administrative processing for over 7 months. Any idea what's the delay as to a final decision? From Anna Khan? Anna Khan, yeah, COVID-19 is a big delay. And also if your spouse, if you and your spouse have certain security clearances that you have to go through, which they will decide at the consular level, then that always takes extra time. Soraya is saying, I suffer emotional abuse in my marriage, and now I have been separated for 3 years. I'm still married to him. I have a baby with somebody else. Can I apply for VAWA? From Soraya. Soraya, thank you so much for your question. And yes, to me, I don't care if you have a baby with somebody else, you are entitled to move on with your life. However, if you marry somebody else, if you get divorced and you marry somebody else, then you would be disqualified from VAWA. However, if you are still legally married to your spouse and you did suffer that emotional abuse and you did live with your spouse and also it was a good faith marriage, then yes, completely 100%, you should be able to file for VAWA. I would love to be able to review your case to see if you are eligible and to see how good of a chance you may have. I would love to help you with that. So don't let this be, don't let the fact that you have a child with somebody else be a barrier to doing this, because it's not going to disqualify you. Okay, 212-248-7907. I filed I-751 extreme cruelty waiver. I don't have enough evidence. Can I switch a divorce waiver? From PB08? PB08, yes, you can actually file for multiple waivers together if you're filing an I-751. But you'd be surprised, you don't actually need to have a great deal of proof for these cases. That's something that some attorneys who are a little bit scared to do these cases say, oh, you don't have enough evidence. oh, you don't have a police report, but that's simply not something that's going to prevent you from getting approved. And I have done so many ECB, extreme cruelty and battery waivers for I-751s. Thanks be to God, everything has gone really well. My clients most of them are almost citizens right now too. And you do not need to have as much evidence as you think. And I'd be happy to take a look at your case. If you have an interview, I'd be very, very happy to help prepare supplemental evidence and prepare you for the interview and represent you at that interview as well. Give us a call, 212-248-7907. I wanted to fix my daughter's father's papers. How will I be able to get him a green card? From Bianca. Bianca, thank you for your question. When you want to fix the papers of your daughter's father, the main thing is that you need to have the proper legal relationship. And usually, in most cases, you need to be married. If you're not married, then there's not much that you can do. There's nothing you can do, in fact. So if you want to have at least a baseline of being able to help, then it requires a legal marriage. Okay. Ali Vegas and Sparky Solutions, thank you for following. Can you tell me about the processing time of 601 in USA? From Arsh USA. If you're doing an I-601 versus an I-601A, usually you're filing this with the fields office, and the processing time will be about the same as long as it takes you to get an interview is usually. Can you apply for VAWA after 2 years from your liquor friend? Can you apply for VAWA after 2 years? And I believe the question is probably, can you apply for VAWA after 2 years of getting divorced? And the answer to this would be sadly no. If your divorce happened more than 2 years ago and you're only finding out now about VAWA, then you may be disqualified from doing it. But if you're still inside the 2-year period after getting divorced, then yes, I would love to take a look at your case, okay? But just because you may be disqualified from doing VAWA, I'm going to talk about 2 scenarios where you may have other options. Number one, some people may end up getting divorced and never know that their spouse tried to divorce them. Number one, if if your spouse wants to divorce you, they have to legally serve you with the papers. And something that I see in some cases is that people will do it in a very shady way. They won't actually serve you. You'll never know about the divorce, and thus you lose your rights. And when I see cases like that, then I actually recommend to reopen the divorce case in civil court to contest the divorce, because you never got proper notice and you're entitled to have a hearing on this. And if you're able to reopen your divorce, then there's no divorce, and then we can go back and file for VAWA in that situation. Second is, if that's not possible, then I would actually look to see if you were basically treated like a slave in your marriage. Did your spouse force you to do everything? Did your spouse force you to work, force you to do things in exchange for things as simple as food? Did your spouse ever physically hurt you to the point where, you call the police? You may be eligible for either a T visa or a U visa in those situations. And I'd also be happy to help take a look. Can I petition for a cousin? No, you cannot. I'm so sorry. Any update on DACA? There's no update on DACA, my friends. I'm really sorry. But as soon as there's any sort of update on DACA, I will be sure, that I will be sure to do a video on that. Will I be able to work in Dallas, Texas? I just had a question. Give me one sec. Yes, I actually have many, many cases in Texas. I have many cases all over the U.S., Texas, California, Phoenix, Florida, throughout the Midwest, in Chicago. Like, there's a lot of states and cities that I have cases in all over the U.S. I don't think I have a case in Alaska or Hawaii, but, if you're watching me and you're in Alaska or Hawaii, give me a call. However, you don't have to worry about a thing, because we're in year 2022. And one thing that COVID has done is COVID has made me and my team really super efficient at working virtually with clients to make it as easy for them as possible. Let's see. Sorry, guys, I may miss some questions because it just scrolls up quite a lot. Let's see. My mom has been having her paper submitted since 2000, but they keep telling us she can't fix. From Princess Maggie. Princess, your mom may have a problem called a permanent bar, most likely. I'd be happy to review her details to see if she is able to fix, even though she has a permanent bar, because there are actually 3 types of cases that I look at for people who have the permanent bar. And in these 3 sorts of cases, which I'll do a video on later today, there are potential fixes for the permanent bar inside the US. How long does it take to apply for a green card with a spouse? It usually takes about a year. How many years in do I place paperwork for the 10-year deportation from Lexa? Lexa, I believe you're talking about something called cancellation of removal. And cancellation of removal is a type of defense that you give in court in front of a judge when you have been put into deportation. And cancellation of removal is something that you can ask for when you have been in the US for at least 10 years, and you also have a US citizen spouse, child, or parent, I believe, who would suffer exceptional and unusual hardship without you here. You definitely need to be in court. You cannot ask for this outside of court, okay? Thank you for all the follows, everyone. How long does the residency process take if I were to start it for my mom once I turn 21? From Sobriana. So Sobriana, once you turn 21 and you want to petition for your parents, the process can take anywhere from a year or to a little bit more. Also, it depends on what sort of case your parent needs. If your mom or dad has a legal entry into the U.S. and you're able to petition for them right away, usually that process will be about a year. Also, if your parent does not have a legal entry, then we look to see if they're eligible for Section 245I adjustment of status or military parole in place. It's also about a year. But if your parents don't qualify for that, they don't have a legal entry, or they have the permanent bar, then I look for other cases to see if it might help, including VAWA, the U visa, or the T visa. I'm a U.S. citizen and I have 2 kids as a parole to U.S. Can I apply for their citizenship directly? From Sally King. Sally King, you need to contact us for an appointment, okay? Do you help with visitor visas? I do not help with visitor visas, unfortunately. All right. Hello, I applied for a green card after married with a citizen, and we had an interview, and we got an RFE from La Jolla. La Jolla, definitely a request for evidence or the RFE you can definitely get even after the interview. Make sure you respond to it right away on time, okay? And hopefully you'll get your approval after that. Oh, and La Jolla has given some more information. I applied for the green card. We get an RFE. But I can't continue with her because of the abusive relationship. Can I convert to a VAWA? La Jolla, and you have a restraining order as well. Definitely. La Jolla, please give us a call, 212-248-7907. I would love to be able to help you. You can definitely convert your case. Even if your case gets denied, we can still file for VAWA, okay? But give us a call soon, okay? So we can see if we can save your case. Why are they taking forever? How can I ask without risking any of my husband's process? From Aridelis. Aridelis, why is immigration taking forever? That is the perennial question, which we don't really know how to answer too well, other than to say that COVID-19 has done a number on all the government agencies, and that's one of the reasons why things are taking so long. But if you have a reason to expedite, you can definitely ask for that. All right, give me 1 second, everyone. I'm just scrolling through for some questions. How long will they see the permanent resident after interview? From Ms. Rivera. Ms. Rivera, I'm not sure I understand your question. I think it's about basically once you become a permanent resident, how long do you have to wait in order to apply for citizenship? And the answer is either 3 years or 5 years. So if you have gotten your green card on the basis of marriage, or you've gotten it on the basis of VAWA, or you have removed your conditions pursuant to an extreme cruelty and battery waiver, then you only have to wait 3 total years. You have to accumulate 3 years of residency to apply. But if you got your green card in any other way, you have to wait 5. Okay. I'm here since 2014, but I opened my asylum file. I am married to a U.S. citizen, but I have problems in my marriage. Can I apply for VAWA with the green card together? From Peter Patel. Peter Patel, thank you for your question. And this is actually a good question that I get from a lot of people. What happens if you have a pending asylum case, but you're also married to a U.S. citizen and you're having lots of problems in your marriage where you feel like you are suffering a great deal, can you apply for VAWA? Yes. And the answer is yes. I would be happy to take a look at your case to see whether you fit all the eligibility requirements. But definitely, if you're having problems, you're suffering, you're scared, you're feeling tortured emotionally, your wife is physically hurting you, keeps putting you down, threatens to call immigration on you, even though you're already in an asylum process. These are a lot of common things that you would be surprised to hear are more common than not. And if it's happening to you, then yes, we could still file for your VAWA, even though you have an asylum case pending. We would definitely have to take care of the asylum case at some point, whether it means to proceed or whether it means to withdraw. It really depends on your case. But give us a call, Peter. I'd love to help. 212-248-7907. Ivan Petrovich, hello. Can I apply for DACA if I was 18 when I came to the U.S. by a J1 visa at 2010? So for DACA, anyone who wants to apply for DACA, you need to have been in the U.S. Between 2007 and 2012 without status. So if you had status during that time, then it's not going to work. Okay. All right. Good question. With Stephen Breyer gone in the Supreme Court, will it mean positive things to come? Possibly. Gabby, thank you for your question. Good to see you. All right, let's talk about this. We may possibly get the chance to have a more liberal Supreme Court justice on the bench. Is it a possibility? And number two, is it going to make things better? Now, I think it is always a good thing to have somebody who is a liberal on the Supreme Court. Will it make much of a difference at this point? I don't know, because at this point, the bench is majority conservative anyway. But second, I think that it's going to happen. And I think that we always have to keep pushing for, younger people to get on the bench, because people will retire. And then as people retire, they need to get replaced. So I think that it's a positive thing, but it's not going to be an immediate positive outcome. But thank you for that question, Gabby. All right. Should I stay in the country for applying for VAWA, or can I go back to my country after I apply for VAWA from LIAC? LIAC, you can actually go back to your country if you apply for VAWA. You do not need to stay here in the U.S. However, you will have to go through your country's consulate for the actual immigrant visa. It will probably take a little bit longer to get back to the U.S., okay? All right, just a couple more questions, guys. What are the qualifications for filing for a green card while married to someone born in the U.S.? From Almiti King. Almiti King, if you are married to someone born in the U.S. and you filed for a green card, the basic qualifications are this. Number one, you need to have a lawful entry and inspection. Number two, you cannot have certain disqualifying convictions or other offenses. And number three, your spouse will also need to make the minimum requirement. And there's some other things as well, but these are the main things that I feel like most people should know about. But if you don't have a legal entry to the US, or you have other violations, then we would definitely need to look to see if you qualify for a waiver or if you qualify for VAWA, which does not require a legal entry, okay? All right, everyone, I got to get going, but thank you so much for watching. Thank you to all of you for your questions. I'm sorry I could not answer everything, but stay tuned and I'll be back soon. And I hope to see everyone again. Thank you so much.